What is an estate plan? That's what we're going to tackle in this video. My name is Amy Rafeka. I'm an attorney. I founded Atlanta Wills and Trust Law Group in Atlanta, Georgia. And we prepare estate plans all the time for clients, so we know what they are. But we also recognize that many times when we first meet potential new clients, that they don't understand that term estate plan, and they certainly don't understand how to get one. Well, we're going to tackle that today. We're going to also break down what is an estate? How do you get one? How do you plan for it? And really specifically, if you have an estate plan, what kind of decisions should you make in that estate plan, and what documents are included in that plan? First, let's tackle what is an estate. Well, during your life, you have things, you have money, and maybe even you own a home. When you pass away, you can't own those things any longer. You can't own the money. You can't own the property. You can't own the things in your life. And that property interest, that ownership, has to go to someone else. So your estate is the owner of that property until it is decided what person it goes to. So it is a temporary owner of the things that you owned, the money that you owned, and the property that you owned during your lifetime. And it does need to be wound down. It has to end. Your estate does have to end. And so when it ends, that means that ownership in the money, ownership in the property, and ownership in the things needs to go to another person. And so your estate plan is the plan for who your money, your things, and your property go to after you pass away. So let's talk about specific decisions that typically go into creating an estate plan. Well, the obvious that we just talked about, which is who will get my things, who will get my money, and who will get my property when I pass away. Of course, many times people choose their spouse if they're married, or many times they will choose their children if they have them. But this is also an opportunity for someone to choose to be charitable and to do charitable giving in their estate plan and give a certain amount of money or certain things to charity. Also, decisions that need to be made in your estate plan have nothing to do with your things, your money, or your real property. Those decisions are, what happens to my body after I pass away? If you wish to be cremated, then your estate plan needs to address, one, that you're okay with being cremated, and two, who you wish to authorize the cremation of your body. If you wish to be buried, not cremated, you can authorize that as well, and you can indicate that that is your choice. You really should also designate the person who is responsible for carrying out your wishes as it relates to your body and what happens to it during the services or funeral after you pass away. You also want to decide in your estate plan, not things even related to when you pass away, but things when you are alive. Your estate plan needs to address the fact that there is a good chance that you may need someone to help you manage your finances and manage healthcare decisions while you are alive. This sometimes is referred to as incapacitated. And this just merely means you are legally unable, to manage your finances or manage your healthcare decisions. If during your lifetime you become incapacitated, You need to designate an individual who can manage your money and your finances and manage your health care decisions. These documents are typically referred to as powers of attorney. The finance document is referred to many times as a durable power of attorney for finances. And the person that you choose to make decisions for you if you cannot is called your power of attorney, sometimes referred to as an agent. For healthcare, this particular document can be named a few different names. It too can also be named a durable power of attorney for healthcare. Sometimes your healthcare document, though, is referred to as an advanced directive for healthcare. Let's first talk about the finance document. This document, there are several decisions that need to be made in this document. Everything from whether you would like for it to take effect immediately or only if you're incapacitated. You also want to make sure that your first choice for a power of attorney has a backup. And you should really walk through whether or not those people that you place in that role has your best interests with regards to your finances and will make sure and protect that money to be used for your benefit and your benefit only during your lifetime. In addition to the finance document, there is the healthcare document that we mentioned. In this too, you should designate a person to be responsible for making decisions for healthcare if you cannot. Like the finance power of attorney, the healthcare power of attorney has many decisions to make within it. Some of these major decisions include whether or not you wish to remain in your residence during your lifetime for as long as possible and receive care at home, or whether or not you're comfortable going into a care facility, such as an assisted living community. Another major decision that needs to be made in your healthcare document is, again, whether or not your advocate or your power of attorney can make end-of-life decisions. Let's talk about end-of-life decisions. Sometimes these decisions get very confused with treatment decisions. Healthcare decisions with regards to treatment are those kinds of decisions that relate to you otherwise need to maintain treatment in healthcare, such as what prescriptions you might take, whether or not you're taking your prescriptions properly. End-of-life decisions are different than the decisions with regards to treatment. So, for example, the end-of-life decisions relate to your life is being artificially prolonged by a particular type of medical procedure being administered. The strongest one that comes to mind is that your heart is beating only because a machine is beating your heart for you. If not, you would otherwise pass away. And this is not a life-sustaining type of procedure and treatment to wait, for example, for a heart transplant or because something is going wrong elsewhere and the doctors are treating it. End-of-life decisions really are about there is no chance of recovery, that it is only merely prolonging artificially your passing. And these two types of decisions commonly get confused, but the best way to describe the difference between a healthcare power of attorney decision and an end-of-life decision in an advanced directive or living will is a healthcare decision is really about treatment, and a living will and advanced directive decision is really about a procedure being administered that's artificially prolonging your life, artificially prolonging what is inevitable. So The healthcare power of attorney is really a powerful document in that you need to choose someone who is going to advocate for your choices about what you want relating to your healthcare treatment and what you want related to your end of life decisions. And sometimes this can get very difficult for family members who are grieving and who are upset because either an expected or unexpected health crisis has precipitated the need to make decisions. So you really want to make sure that you choose someone who can advocate on your behalf for what you want. The other document that's really important in an estate plan is a nomination of guardianship and conservatorship for a minor child, if you have minor children. If you have a child under the age of 18, you have a minor child. You should really designate someone in your estate plan to care for that child if you cannot. You should also make sure that you're addressing that even if you're alive and cannot care for your child, you choose this individual to do this for you. Many times estate plans overlook that it is possible for you to still be alive, but just unable to care for your child in a temporary or emergency situation. Most estate plans only address what happens after you pass away, which is important, but one should not overlook that you also need to address if you are alive and you cannot manage your children and care for your children during your lifetime, you really should designate an individual to do that for you who would carry out what you want to have happen for your child. The final document that I mentioned is not always in all estate plans, and it is used for very particular reasons if you have goals in your estate plan, and that is a trust document. And trusts aren't for everyone, but there are some really common reasons why you might choose a trust. And those reasons should be discussed with the professional before you decide whether or not it's appropriate for you. Trusts aren't for everyone, but for those people who it is appropriate for, they're very powerful tools and can really help families preserve monies, things, and real property and protect those things for the benefit of another, which is really what a trust does. It protects those things for the benefit of another individual. Well, I hope that you have learned something about what an estate plan is, and specifically the documents included in an estate plan should be a last will and testament, a financial power of attorney, a healthcare power of attorney, an advanced directive or a living will, which is your end of life decisions. And if you have minor children, your estate plan should also include a document, nomination of guardianship and conservatorship for minor children. And occasionally, estate plans would also include a trust document. If you have questions about what any of these documents are and whether or not they're appropriate for your family and for those loved ones that you would love to protect, reach out to us at Atlanta Wills and Trust Law Group. Our phone number is 770-508-6525, and you can schedule a consultation to come in and talk about who you would love to protect in your estate plan and why you would love to protect them and what potentially could fall into your estate plan and what decisions you would like to make. This is attorney Amy Rafeka of Atlanta Wills and Trust Law Group. Thank you so much for joining us. If you have questions and comments about this video, you're welcome to drop them in the comment section below and we will respond.